Hi, it's Ron. So let's pick up where we left off with last week's lesson, which was pre-litigation investigation, as well as conflict checks. Now we're going to go forward with filing the lawsuit. I'm going to put aside the issue of whether you sue in state court or federal court, because I think we've dealt with that in the last couple of lessons. We might want to come back to it at some point, but for now, let's talk about filing the complaint. A complaint is how you start a lawsuit in almost every circumstance. What's a complaint? A complaint identifies the parties, you, the plaintiff, and any defendant, which is the person you are suing. There may be more than one, multiple defendants, addresses, and then you recite the facts which are relevant to set out the nature of the claims that you are making against the defendants. There can be more than one claim in a lawsuit. You can sue someone for breach of contract, and also include a related claim such as a book account. I'm not going to get into all the different kinds of legal claims that a person could make. Maybe there was also tortious interference with contract that took place after some termination. There's a wide variety of different kinds of claims. But the point is, you're allowed to do something called pleading in the alternative, which means they did to me A, B, C, D, E, F, and that is a wrong that was done for me. I've been damaged by that, and you need to, in your complaint, allege that you've been damaged, and you need to come up with a match for how those facts amount to a legal wrong as opposed to just a wrong. So therefore, there could be more than one legal theory that allows you to recover. There are some special pleadings rules, but before I get to those, I want to talk about a quirky aspect of New York state court practice called a summons and notice. First, let's establish you start a lawsuit by filing a complaint. Then you take that complaint and you serve it on the defendant. You say, hey, guess what? I sued you in federal court in Newark, and you attach to that complaint a summons, which has been filled out by the clerk of the court or a person authorized by the clerk of the court. And for example, in New Jersey state court practice, every New Jersey attorney is authorized to sign a summons on behalf of the clerk of the court. And you're saying, I'm inviting you to court to defend yourself. Well, or if you don't want to defend yourself, that's fine, but I'm telling you that I'm going to court to seek relief for the damage that you've done to me. When you have served the summons and complaint, the summons that has been served, a copy of it is filed along with an affidavit in the court saying, hey, guess what? I filed this complaint on January 1st. Let's say January 2nd, because the courts are closed on the 1st. Doesn't really matter now, but with electronic filing, you can file whenever you want. And I served it 5 days later on January 6th or 7th. Here's my proof of service. That's a really important proof of service. Once you have served the defendant or defendants, the courts have a terminology that is used, which is that issue has been joined. In other words, it's time to rock and roll. Now, it is possible under some circumstances for the defendant to dispute that service was proper. What is proper service? You can serve a person in person. You can serve a person or a corporation or other legal entity by serving that person at his or her or its place of business or residence, or serving, if it's a corporation, a corporate officer or a person authorized by the corporation to accept service on its behalf, such as what's called a registered agent, and on the Secretary of State of the state where that legal entity is incorporated or formed. That's one of the deals that you make with the world when you're permitted the privilege of establishing a legal entity that in most cases will protect you from personal liability for the actions or obligations of that legal entity. You have to be available to be sued to at least establish what those actions are or what those obligations are. Meaning that if we can't sue you at your headquarters, and maybe a security guard doesn't let us in, and there are lots of different fine points about how that can look. You can make service on the Secretary of State. That often leads to some interesting adventures in and of itself. But once service has been made and service is good, issue has been joined, and then the defendant has 20 to 30 days, depending on where you're suing them, and assuming it's not a government entity, they get extra time. They get 30 days in federal court as well. 20 days or 21 days to answer, to file and serve the answer, or a motion to dismiss saying even if everything in this complaint were true, I'm not saying it's true, but even if it were true, none of these legal theories would provide relief for the plaintiff. Now, I mentioned something about a quirk in New York practice. One of the things that happens when you file a complaint is that you stop the running of a statute of limitations. Let's say you're suing for a breach of contract, and the statute of limitations for the breach of contract is 7 years. You must sue a person that you believe has breached a contract with you within 7 years of the breach. And that means you have until 7 years after that breach to file that complaint. What if all of a sudden you realize you never sued, or you waited too long? Well, you can have a big problem if you wait too long. But one of the things about New York state practice is they have something called a summons and notice. And a summons and notice is where you file something called a notice. And instead of being a complaint that actually lays out what the case is, what the actual claims are, it's sort of a placeholder and says, we're suing you for medical malpractice. I'm John Smith. I had an appendectomy in your office, and I'm going to get back to you with the details, but we're putting down our marker here for satisfying the statute of limitations. That works in New York. Then you have to serve it promptly, and that gives you additional time to file the complaint. It's an unusual procedure. It's certainly not used in complex commercial litigation, but it is kind of an interesting thing to know about. The complaint is supposed to just be bare bones. It's not a place for putting evidence into the record. You don't have to prove your case in the complaint. You don't have to put in the emails that you claim were the renunciation of the contract or the breach of the contract or or even the contract itself. It is very common to put more information than is needed in order to give the court a full sense of what it is you're claiming and why you do have a right to the relief that you're requesting. I mentioned something before about special pleading requirements under federal law, and the law, I think, probably in most states, called 9B of the Federal Rules of Civil Procedure. And it requires that in the case of an allegation of fraud, more detail is needed to sustain a cause of action in order for you not to be thrown out of court based solely on the argument that even if it did happen, there's no legal claim for it. When it comes to fraud, the allegation of fraud is an allegation that you made a misrepresentation to me that was material. In other words, it mattered about some financial or business transaction that I entered into, relying on your representation. In other words, on what you told me. It was reasonable for me under the circumstances to rely on your representation. I did so, and because I relied on you, and it turned out to be false, and you knew it was false when you made it, I lost out. I was damaged. That's an allegation of fraud. So the pleading requirements for an allegation of fraud, and that doesn't only include the tort of fraud, that can also include any tort which includes, which as they say in the legal decisions, sounds in fraud. In other words, it has a fraud component to it, such as fraudulent misrepresentation, many other kinds of legal claims. If it's such an allegation, if it sounds in fraud, you need to plead more specifically than for a breach of contract. Why? Because a fraud, the general idea of this kind of the bare bones pleading, which is called notice pleading, which means I'm just telling you what I'm suing you about, which contract it was we entered into. And then, we go through the process of pretrial discovery, but when it comes to fraud, you need to tell me who it was specifically who made the false misrepresentation, what that misrepresentation was, what basis you have for knowing that I knew it was false when I made it, and how you were damaged. That is a higher level of detail than is necessary under the general notice pleading standard. So now we're in court. We've filed our claim. We have properly executed summons. We serve the defendant with the summons, and now they're part of the judicial proceeding. They have been invited, summoned to court to defend themselves against this dispute. And next week, we'll take it from the next step. Thanks for joining me.